Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to this week's episode of our Curious Amalgam, the official podcast of the American Bar Association's section of Antitrust Law. I'm Matt Reynolds. Today's episode is Still Going Strong at 20, a conversation with the architect of the EU Merger Regulation 2004. Here in the United States, there are a lucky few among us who dwell in the arcane and often Byzantine realm of the Hart-Scott-Rodino Antitrust Improvements Act of 1976, and the ever-growing body of associated rules, practices, and interpretations promulgated by the Federal Trade Commission and the U.S. Department of Justice. Across the pond in Europe, a comparably lucky few practitioners have dwelt for the past 20 years in the parallel realm of the 2004 EU Merger Regulation. As competition lawyers stateside are anticipating new rules and interpretations from regulators here, today we are taking a retrospective look at that landmark 2004 regulation and its development and application in the 20 years since its passage. I'm joined today by my co-host, Matthew Hall. Hello, Matthew.
Hello, Matt.
So let's turn things over to you to introduce our esteemed guest for today's conversation.
Thanks, Matt. Our guest today is Sir Philip Lowe. Amongst many other senior posts within the European Commission, Philip was Director-General of the Commission's Directorate-General for Competition, or DG Comp, from 2002 to 2010. He was the first non-German to hold that post. Reporting to the Commissioner for Competition at the time, Mario Monti, in that role he led implementation of the changes to the EC merger regulation, now what you referred to as the EU merger regulation, which were introduced in 2004, so 20 years ago this year, 2024. Before that, from 1993 to 1995, Philip led DG Comp's famous MTF, the Merger Task Force Unit, which dealt with EC merger regulation cases. Hello, Philip, and welcome to the show.
Thank you for that welcome. I'm delighted to see colleagues again from the antitrust world in the US.
Excellent. Merger control at the European level dates back to 1990, when the original merger regulation 4064 of 1989 came into force in what was then called the EEC and is now the EU. The EC merger regulation, ECMR, introduced a one-stop shop for large acquisitions, mergers, and certain JVs affecting the EEC based on turnover thresholds. The basic procedures of the ECMR remain in the EU merger regulation 2004 today, which we're going to be discussing. Just by way of brief outline of those procedures, under the regime, then and now, filing of qualifying transactions with the European Commission in Brussels is mandatory. Transactions have to be cleared by the Commission before closing. National rules continue to apply to smaller transactions. Appeals against Commission decisions, which are to approve, conditionally approve subject to remedies or prohibit transactions, can be made to the EU courts. The substantive test introduced in the ECMR, now changed in the EU MR of 2004, was that a transaction is blocked if it would create or strengthen a dominant position that it could impede effective competition within the EC, unless remedies were agreed. As Matt mentioned, the ECMR is replaced by Regulation 139 of 2004, the famous EU MR, or EU Merger Regulation, which we will discuss today. So Philip, that was a brief introduction. You were, under Mario Monti, leading the EU MR introduction in 2004, replacing the ECMR. Can you just outline what was happening at the time within the Commission, the lead up to those changes, and in particular there were some very significant court judgments around the time which played a big role in that?
Yeah, thanks, Matt, for that introduction. I mean, I've been associated with the inception of merger control at European level from 1993 onwards, and of course it was regarded as a bit of the Rolls-Royce of the antitrust world in the European Union, because we established legal deadlines. We had a one-stop shop for all the 15 member states at the time, and it looked pretty good, and it put actually into the shade a lot of the other things in the antitrust ballpark of what the European Commission was doing, because we had a massive backlog of antitrust cases which were decided not on the basis of self-assessment as was the case in the US, but were actually subject to notification of agreements. So there was a lot of discontent throughout Europe, particularly in business, about the way in which competition policy was applied, except for the merger area, which was regarded as as leading the pack. And so when I rejoined the DG Competition in 2002 as Director-General, well, I knew that we had to do something comprehensive in terms of improving the efficiency and effectiveness of competition policy at the European level. And that was already foreseen through the parallel regulation which was under discussion at the time, which was to modernize antitrust and to move to a self-assessment system. And in parallel indeed to that was the impression that the way in which competition law had been applied in the European Union was relatively formalistic and legalistic, and so an injection of a more economic approach was at least one of the titles in the headlines of the day. How can we actually make this regime, whether it was mergers, antitrust, cartels, whatever, and state aids, by the way, how can we make it more credible in terms of its effectiveness and its efficiency? Now, as I came into that role, and Mario Monti was in charge at the time, we had, as Matthew has reminded us, also the arrival of subsequently three decisions in 2002, overturning merger prohibitions decided by our elite merger task force. And when we say decided by them, obviously, I mean recommended by the merger task force and authorized by the Commission as a whole in that process. And so basically, Mario Monti and I were on a burning deck there, because the one part of the ship which seemed to be working well was the merger task force, and yet at that very moment arrived 3 or 4 Exocet missiles from whichever aircraft we don't know, but the missiles of the court judgment said, frankly, Commission, you're not doing your job effectively in merger control. It's not just a question, as we say in European law, of manifest error, legal errors. You fail to analyze the evidence, the facts behind your analysis, and you've actually prohibited things which should not have been prohibited. So that was the overall context we were in. I would say if I refer to a burning deck, I mean seriously that, because it did affect a lot of the political credibility of not just of DG Competition, but of the Commission as a whole.
The burning deck seems like a correct comment, Philip. There was very wide media coverage at the time. In Air Tours, one of the cases, I think the General Court said that the Commission had engaged in, quotes, errors, omissions, and inconsistencies of utmost gravity. So this was a bit of, as you say, this was a bit of a crisis, but was it turned into an opportunity as a result?
Well, I would say personally, it was a good moment in certain respects for me, because I knew I had to reorganize the department to move, in my view, towards a more economic approach, to revamp the area of application of antitrust laws outside the merger control area. And therefore, that psychology of the need to reestablish our credibility obviously helped in terms of pushing through reforms which would be more difficult to do if that situation had not, that the court judgments hadn't occurred.
Yeah, you refer to some of the changes there, Philip. You refer to the introduction of economic expertise. Another chief economist was brought in at that point. You refer to internal decision-making procedures as well. For the proposed changes to the EUMR, then introduced in May 2004, what were the other key points or point within the regulation itself?
I would just say to all the listeners and viewers on this, we're looking back at 20 years of application of our recast merger regulation, but the key changes actually, which were resulted from the court judgments, were in the way in which the Commission organized itself in terms of merger control, in terms of concentrating more on how markets are working rather than simply applying legal instruments. And I reorganized, and with Mario Monti's backing, the DG Competition on that footing. At the same time, we were able, because there was a review of the merger regulation itself, to tackle issues which were not life-threatening, but which were important, I think, personally from the point of view of international convergence, but also the credibility of our own economic thinking inside the European Union, which was, first of all, we were discussing whether it was sufficient to say that a merger could only be opposed on the basis of strengthening or creating a dominant position, rather than looking at situations on markets where, whether or not the number one dominant player is involved, the effect of the merger is actually to reduce competition. So instead of having a merger test which said mergers will be controlled relating to the dominance criterion because that affects competition, we reversed that test and we said basically anything which is an impediment to competition, including in particular dominant creation or strengthening of a dominant position. That was the major change in the regulation, which I think helped convergence inside the European Union among the national competition authorities, as well as with internationally with the US and elsewhere. The second major change in the regulation, which I thought was a precursor of what's happened since, is that we started to build in methods to refer cases from the European level to the national level or vice versa in application of what I would say was actually also in the modernization regulation of the on antitrust, which was who should deal with the case in Europe? Well, the authority which is closest to the facts, which knows more, is likely to know more about what's going on, and also can execute decisions, whether remedies or elsewhere, in the most effective way. So we started in that first draft regulation, the change to the merger regulation, to strengthen the capacity for national authorities and for the Commission to send each other cases in one way or another. And I think that's proved to be a successful process which has been strengthened on several occasions since 2002.
Yeah, that's regularly used, of course, Philip, now. And so you refer to the SIEC test, which really was meant to plug, or largely intended to plug the enforcement gap, but also bring the law in line with, in particular, the US. I think there was also a horizontal mergers notice adopted, again, bringing the law fairly in line with the US practice at the time. It's interesting to see your comments on, you see it, of course, in a wider, more holistic approach of what the Commission was doing generally, not only in the area of mergers.
And just for the benefit of our young listeners and perhaps our non-EU practitioners, the SIEC test, that acronym is Significant Impediment of Effective Competition, is that right?
Yeah, which is more or less SLC in your terms.
The SLC,
Perfect.
of course, being the original idea in the 2001 Green Paper, which morphed into the SIEC test ultimately, didn't it?
Yeah. Frankly, anecdotally, I have to say that the biggest opponents to that change were not outside the Commission; they were inside the Commission.
Interesting.
And this is always the case with any kind of major reform. Watch out for the people right next.
Is that called institutional inertia, Philip, possibly, or something like that?
Yeah, and also, in Europe, certainly. Cultural traditions, for example, as far as our German colleagues were concerned, the move away from the dominance test was a bit heretical, because of course we can take into account gap tests, but in the margin of dominance. But I think the clarity which was given by the recast merger regulation of 2004 was to say, no, we're looking at holistically at anything which lessens competition, in particular dominance.
If I might ask one additional question on this point, we talked a little bit about those 3 general court decisions that served as the impetus for this process leading up to the 2004 regulation. One of the challenges that we face in the United States as antitrust and competition practitioners, especially when dealing with courts in merger challenges and in other contexts, is educating the decision maker who may be a generalist jurist and not someone who may have ever practiced antitrust or competition law before. And I'm just curious, talking about those general court decisions and the changes that they wrought, was there also in that process a greater focus on creating a process that would yield results that would be intelligible, understandable to a court of more general jurisdiction that may or may not be an antitrust or competition specialist body?
Of course, we're comparing 2 systems which are different. One, the U.S. prosecutorial system, and the capacity of judges to take informed decisions on that basis, whereas in the administrative system of the European Union, you're relying on judges to basically vet the decisions already taken by administrative authority. But I think that there is one common theme in it, and that is you've got to tell a convincing story. And before to judges, and before 2002, and I have to say I pay homage to a number of the colleagues we brought in at that time, in particular Henrik Röller, went back to Germany after that, but was an economist with great distinction, with trained a lot in the States, but also trained a lot in Germany, had credibility. He was the first guy to actually start people saying to colleagues inside the department, well, on this case, what is your theory of harm? And instead of saying, well, yes, this merger should be blocked, whatever it is, what is your theory of harm, and what is the evidence you've got to back up your theory of harm? That was a discipline which I think is one which has been established since 2004. I think sometimes economists go too far in asking for too much data, too much time to reach a decision. We can't have decisions taken within legal deadlines unless you take decisions sometimes without all the information you need. But the fact was that was the major sort of cultural change inside the department.
That's very interesting, Philip. I mean, of course, theory of harm is the standard kind of basic question and analysis now, isn't it? So moving the clock forward a bit, as we mentioned, you were Director-General up to 2010. You've referred to resistance within the Commission to the potential change to SLC, then ultimately the change to SIEC, which was adopted. And what was the view within DG Comp up to 2010 on how the changes in the 2004 regulation had played out in practice? And also, of course, the internal procedural type changes, I guess, as well, which you correctly commented were so important.
Yeah, there was a lot of, I put, and Mario Monti put a lot of emphasis on internal checks and balances, testing ourselves, whether our cases could be pursued through the courts up to the appeals in courts, and whether or not we were going to win them or not, at least we should know exactly what we were doing. Because often, and this is a self-criticism because I've been involved in a lot of work at the Commission in many areas. The European Commission, like many public authorities, tends to assume that its work is finished when it's taken its decision, but it never is. You've got to think through that right from the beginning. So that was that process of checking what we were doing, devil's advocate panels opposed to the case team, making sure that the commissioner had direct access to the case team, so that there was no filtering of information or bias in the views taken by presented to the commission. That was extremely important in getting the procedures right. Now, since 2004, I think, broadly speaking, the way in which decisions have been taken in front of the commissioner or prepared in front of the commissioner, chief economist on one side, the legal service on the other, the case team in the middle, the Director-General or the director able to sometimes disagree with what the case team says, which does happen. That's healthy and it's transparent. And I think maybe if I had been in charge after 2010, maybe I would have involved perhaps the court more in the due process later. There is a hearing officer in the commission for those issues, but perhaps it would have been interesting in certain cases to get the courts involved in that process. But I think that's relatively minor compared with the effect that the internal checks and balances brought in the Commission's work. Of course, since then there have been cases where the Commission has won in court and sometimes it's lost. But the way in which those reforms were thought through in 2000 were thorough and comprehensive and prepared us for the shocks to come forward. And the other thing I'd like to say is that I didn't pursue those reforms on my own. I asked groups of officials of the DG Competition itself to prepare the proposals. So there was a huge element of cohesion in that process, which you can say, well, right, that was because you had a burning deck and you could make it work. But frankly, there was a lot of solidarity there, and it's contributed to what I think is a relatively reasonable reputation of DG Competition worldwide. We were never, I think we were number one equal in GCR in 2005, 2006. Maybe we're 2 or 3, and maybe there are some commentators now who will say that both the US authorities and the Commission are under-enforced.
Yeah, I think you're probably a bit modest when you say the Commission has a relatively reasonable reputation, but it's also interesting to hear how you actually do look at GCR like the private practice lawyers do. Are pleased to be listed.
Yeah.
Philip, you refer to some wins and some losses by the Commission. Of course, a famous case from a couple of years ago now, which was looking at the oligopoly gap, was the CK Telecoms judgment. Commission originally blocked in May 2016 a UK mobile merger as a 4-3 case. That was then annulled by the General Court in May 2020, but then that annulment was then overturned by the Court of Justice. What are your thoughts about where that ended up and what it shows, if anything, about what we've been talking about today?
Well, I honestly think that what I will say now will shock many people, including judges.
Well, that's good. We like to have that on the podcast.
But frankly, in 2002, it was a real surprise to find that we had judicial review of that strength. There was an assumption, more or less, at that time that if the Commission decided against the merger, that was it, unless it made a huge legal error. In fact, that process, those judgments under Westerdorf in the what's now the General Court, were important in saying to the Commission, you're not in a bubble, taking decisions on your own. You are in the real world, and the real world requires questioning of your decisions where necessary. As again I said, tell a convincing story. Where is the evidence? Is it legally correct? And that process, in my view, has resulted in that wake up call to the Commission has resulted in a much more considered approach by the Commission, but also a much more active role for the courts. On Article 102, for example, I've always said that until 2000 and at least until 2010, when I left, the case law of the European Union on abuse of dominance was Jurassic, and it needed to wake up to what was going on, which is why we produced a paper on priorities for enforcement in 102, which is now being relooked at again in terms of draft guidelines on 102. And I think what's refreshing about this is that we're in process of building a European system which has application throughout the 27 member states of the European Union, which is clearly accountable to courts, is clearly accountable to wider society. And I think that the decisions on whether it's the General Court or the ECJ, we've been going backwards and forwards on some of those cases. That's healthy. It sometimes takes more time, but on the whole, the courts have improved the delays for looking at cases very considerably. And I don't think, compared with the other jurisdictions in the world, anyone can complain about this.
Yeah, you talk about still building the system. I'd be interested to hear in your thoughts, Philip, on the Article 22 situation. We've had a podcast on Our Curious Amalgam about this. This is the ability of member states to refer up cases to the Commission, which was in that case accepted even where the member state didn't have jurisdiction. The Advocate-General of the European Court has said that wasn't a valid approach. I know that Olivier Gerson, a good friend of this podcast, I think he's been on 3 times now, says that the alternative to that system for the Article 22 referral of that scope would be worse for parties due to uncertainty. What's your view on that situation? And what should be done, if anything?
Well, I've said on previous occasions, that it probably hasn't been noticed, that the process of the development of merger control in the European Union has progressed substantially in terms of process and in terms of judicial review. But there's also been a convergence in a substantive review of cases at national level and at European level. So even though we have thresholds to divide competence between the Commission and national authorities. There's been a substantial amount of convergence of merger, the way in which mergers are assessed. Now, in a situation where you're dealing with the challenge, which was basically at the beginning, how do we deal with small acquisitions, killer acquisitions, which could have significant competition impact later on? Will they escape the net? Well, one way of doing that would be to do, as my German colleagues have done, just change national laws. Say, well, we'll widen the net. We'll catch virtually everything, particularly where the turnover levels are very small. Naturally, one could argue that a national authority has more chance of picking up what is actually the initial impact of an acquisition in that area. But if you're dealing with GAFAMs, you're dealing with big corporations operating worldwide. If they take over an AI company in France or in Slovakia, I'm not sure that the Slovakian authority or the French authority even would necessarily want to deal with the case, because the issues involved go much wider than that, and it's not just a question of the size of the initial acquisition. And in that situation, I think that the story which the Commission has told on Illumina Grail and other situations is convincing that, yes, we should be able to accept cases which have this potential in markets which are particularly European-wide or global. And in terms of this basic concept which we started off with in the modernization regulation in 2003 on antitrust, which is the authority best placed to deal with the case? Well, frankly, if you're dealing with GAFAMs or other things, it seems to me very convincing that there should be a way of referring those cases to the Commission.
Okay, so as we record it, we're waiting to hear what the Court of Justice is going to say on that case, but it sounds like you, Philip, basically support the Commission there. For our final substantive question, I'd be interested to hear as well your thoughts about the future of EU merger control. There's a lot of discussion in Brussels about competition policy against political objectives, whether EU merger control should be offering more support for industrial policy. Even President Macron of France recently made a speech talking about the need to create the old SAW European champions, possibly a derogation from the competition rules to support key sectors. What's your thought about those issues and how far competition law should, and merger law as well, should stray out of its normal route?
Well, I've never seen a particular conflict between industrial policy and competition law. In general, if you stimulate competition in a particular country or jurisdiction, you stimulate competitiveness as well, because if people can't be competitive at a national level, they're unlikely to be competitive at an international level. But that's a sort of general statement about it. I think there's a lot of confusion about the subject, partly because there may be rigidity of thinking about what the solutions could be. For example, if you have two major European companies who have a particular challenge in facing a third country competitor in a particular niche, well, yes, there may be a case for example, for setting up a joint venture of those two companies in that particular sector. in order to challenge the foreign competitor. But to say that in order to challenge that competitor in this particular sector, you have to combine the two companies and create in many other sectors a monopoly. Sorry, this doesn't work. It's not sensible. It's not common sense. You should get into and that's why I think I was appreciated when I was head of the Merger Task Force and Director-General, the conversation with CEOs and others on what solutions could be which would achieve the positive result for them, but which would not endanger competition in the sense of harm deals for consumers and deals for consumers, not just households, but also business to business. So I think solutions can be found where there's a genuine problem in a particular sector, but I don't think that it's sensible there should be a kind of blanket approval to European-wide mergers if they actually create monopolies which are not very contestable in many areas. And I think, frankly, in the US, people would sympathize with that view if you thought about some of the major corporations which could propose that they actually merge inside the US on the grounds that they need to combat Chinese counterparts. It's not serious. But that being said, you shouldn't avoid the subject of creating a competitive European industry, and I think that the measures which are being taken now on control of foreign subsidies is extremely important to do that, as well as the controls at national level on foreign direct investment.
Well, thank you for your very insightful comments, both about the past and the future of EU merger regulation. We like to wrap up each of our episodes of our Curious Amalgam with a couple of questions of a more personal nature to help sort of get to know you as a person as well as an esteemed practitioner. So the first question we'd like to ask you is, can you please share with us something about yourself that maybe your own colleagues don't know about you?
Well, the first thing is that I read more poetry than prose, and I have a lifelong ambition to actually publish a European-wide anthology, which will have to be global in the end, because if you talk about poetry in Spanish or German or English, in the end it's got to be global. The incredible thing is that not many people, it's just like our own newspapers. People assumed 20 years ago that foreigners didn't read them. And then now we got into a situation where, of course, they read them. Of course, we know what the Germans are saying about Monsieur Macron or what we all think about Donald Trump or whatever. Now, in poetry, it's even worse. There are so many poems throughout the world which are actually on the same themes, the same representing the same values, but they're in different languages, and people think that, oh, this is only our area. I want to prove that a little bit wrong, but sharing some of the values and the sentiments expressed by poets, by writers, that's the first thing I would say about they don't know about me.
No, that's wonderful. I have to say, somewhere in my bookshelves, I have a bilingual edition of Pablo Neruda's Residence on Earth.
Exactly.
And I think I also, that makes me think immediately of Walter Kaufmann's really breathtaking translation of Faust. And that's also, I have a bilingual edition of that somewhere. And seeing the rhyme in two languages side by side on the pages is breathtaking. So certainly looking forward to reading that volume of poetry from you.
Yeah, well, if I get time for it after Antitrust.
Absolutely. We typically like to conclude our episodes with a segment that we like to call the Curious Hat.
Oh, yeah.
And now it's time for the Curious Hat.
So, your question this week, which has been chosen at random, is how would you spend the perfect weekend?
Most of the time outdoors, swimming, running, climbing, but also reading, having some time for reflection, and finally, as I think Hilaire Belloc wrote, the laughter and the love of friends.
That's a perfect note to end our episode. Sir Philip Lowe, thanks once again for joining us on our Curious Amalgam, and thanks to our listeners for listening to this episode.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.